Hearing in the Queen on the application of Cardiff and Vale University Health Board and others against Ceredigion County Council and others.
Yes, Mr. Gordon.
May it please your ladyship, my lords. I appear for the appellant, local authorities, with my learned friends Ms Emily Mackenzie and Mr Tom Pascoe. The respondents are represented by my learned friends Miss Fenella Morris and Mr Benjamin Tankle, and the Secretary of State as intervener is represented by my learned friend Mr Clive Sheldon and Miss Sarah Wilkinson. My lady, can I start by explaining the structure or proposed structure of our submissions to the court? First of all, I would like to set out some introductory points, including stating our three core propositions. Then I would like to develop the propositions in turn by reference, where appropriate, to the relevant financial background, legislation, and case law. As we suggest in the very first paragraph of our case, this appeal is concerned with, and I want to stress both of these words, the proper interpretation and application of the statute, that is to say, Section 49 of the Health and Social Care Act 2001. There are, we respectfully submit, and this is why I reverse the order of our submissions as advanced in the case, there are two questions which we respectfully submit apply. The first is a narrow question, and the second is a broad question. The first is a question of application, and the second is a question of interpretation. Identifying the narrow question first, the narrow question relates to the specific funding of registered nurses in care homes. It is which body, local health authority, local health board, I should say, in Wales, or local authority, is legally responsible for the funding of registered nurses who in practice and in any event, in consequence of an express legislative requirement, have to provide the service of being on call 24 hours a day in a nursing care home.
Isn't it a bit more complicated than that? This is not just a fight between two parts of the public purse, which would be bad enough. It's also a fight between each of those and self-funders.
Absolutely. Yes, it's a point I was going to mention probably about halfway through my note, but yes, absolutely.
So the specific funding might come from the health service, it might come from local authorities, or it might come from the residents themselves.
Yes, and I was going to make the point rather later that this is not a technical dispute between two public bodies. It is a dispute which very much affects the service user, as indeed it was in the Cochrane case many years ago. But we say that, if I can fast forward a little bit, we say that the great error of the majority in the Court of Appeal was to treat this as solely a question of interpretation of Section 49, when in fact the real question of application arises by virtue of a concession recorded and accepted by the Court of Appeal, namely that being on 24-hour call to meet health needs is a service within the meaning of Section 49. And cutting to the chase, we say that once that concession is made, recorded, and accepted, we are in the situation of applying Section 49. We are not interpreting it. And that's very important because when one approaches the case from that perspective, what will be seen, hopefully, if we're right in our analysis, is the analytic errors of the majority of the Court of Appeal, who wanted to make what they thought was the correct interpretation of the Act fill all factual situations.
So how can you apply a section before you have interpreted it?
You have to, well, in this particular case, looking at Proposition 1, which I'm going to identify in a moment, once you start from the proposition, which the Court of Appeal did, that being on 24-hour call is a service within the meaning of Section 49, you do not have to interpret service in that context any further, because it is accepted that if a nurse is on 24-hour call to meet healthcare needs, unpredictable, intense, and complex health needs, that's the respondent's own evidence, once you go that far, you are no longer in the process of interpretation. You are applying that which is within the meaning of Section 49. So I'll have to develop it further, but that's where we are coming from on our Proposition 1, which I appreciate I haven't yet got to. Now, it is
But
true...
has that, as I understand it, that concession has been withdrawn?
No, not that concession.
Not
No.
that concession.
If you go to paragraph 16 of the Court of Appeal judgment, which can be found, I think, at page 10, MS page 201, it's really the last 4 lines of paragraph 16. It is clear, this is Lord Justice Laws, it is clear, and now common ground, that the presence of a nurse at a care home at all times, as required in Wales by Regulation 18.3 of the 2002 regulation, constitutes a service within the meaning of nursing care by a registered nurse in Section 49, subsection 2. Now, we say that that concession, which indeed formed the axiom of the Court of Appeal's reasoning, raises not a question, or raises no longer a question of interpretation, because that we proceed from that concession, but raises a question of application. And having approached the case from that basis first, which is the basis upon which we now consider the analysis should proceed, when one comes to the second question of interpretation, it becomes a lot easier to see the answer to it. And if I may again explain why the answer to it is very clear, the answer to it is that the meaning of service needed or not needed by a registered nurse is a contextual one. It is one of context. And the context of care in a nursing home is 24-hour care. The fact that you may be fetching a glass of water for a patient, the fact that you might even be doing nothing in that 24 hours does not mean, as we now know from the concession, that you are not providing a service. And indeed, it doesn't make sense from the perspective of that which a nurse does, the holistic, person-centered treatment of nurses, that healthcare stops atomistically, seconds or minutes, and is then interrupted by social care, and then resurrects itself, let's say, 10 or 15 minutes later. Nor does it make sense that a nurse providing that kind of continuous care could or would ever realistically be expected to record the minutiae of the activities so as to provide the basis for funding later. Indeed, it is true and recorded, and I'll come to the references, but the Court of Appeal all recognized the total impracticability, or implicitly recognized, I should say, the total impracticability of the analysis that they were endorsing. Each of them recognized that. And there are specific passages in the Court of Appeal judgments where that is recognized. But they say, and I'm echoing here, for example, Lord Justice Lloyd-Jones, the tail mustn't wag the dog. That is to say, the regulation must not interpret the section. But of course, once one realizes that one is not in the context of interpreting but applying, the tail is not wagging the dog. It's not that Regulation 18 tells us what Section 49 means. It is that Section 49, when you properly interpret it, is a context-driven section. The words mean the same thing, but the way in which they are applied in different contexts may well be different. And so we respectfully submit that the clue to understanding this case is to start with the concession and then approach the first proposition. What are we dealing with in this case? We are dealing with a nursing care home where one or more nurses, as a result of legislation and evidence, practical evidence, have to be on site to meet complex healthcare needs 24 hours a day. That's the beginning, middle, and end of the application point, but it's also, as I will hopefully show later, the beginning, middle, and end of the interpretation point. Now, my lady and my lords, as I say, I hope I've identified in those opening words the two questions that arise: the narrow question, the application question, the broad question, what I've separated out as the interpretation question. But once you understand the application question, interpretation almost solves itself, because the Court of Appeal in the real world would have had to appreciate that if they were dealing as they were with a narrow question of applying the Act in the face of a concession that was made and which they recorded and approved, it would have been a lot easier for them to have understood that Section 49 means what services are needed in a particular context. Now, that leads me to simply articulate the three propositions for which we contend in turn, so that the court has them. First, we say the majority of the Court of Appeal misapplied Section 49 in the specific context of nursing care homes by failing to hold that the service, which is his common ground it was, required to be provided legally and in practice by registered nurses on a 24-hour basis to meet, when called upon, healthcare needs at any time, necessarily meant that the funding responsibility for the whole of that nurse's time spent on call had to be met by the local health boards. I should say that probably the first instance judge, certainly the majority of the Court of Appeal, and if I may be candid with this court, probably us as well, had not appreciated actually that this case is about understanding application and then moving to interpretation. The one judge who has so far realized this, and it appears in his judgment, it's the dissenting judgment of Lord Justice Elias in the Court of Appeal, and I will come to the point at which he recognizes it. If I can find it now, I will. Yes, it's paragraph 56, manuscript pages 213 to 214. Let's go to that very quickly. This is what really led to our analytically different approach to the case now. So Lord Justice Elias is dealing in paragraph 55 with when they're not called upon, what service is being provided, comes to the conclusion that when they're on standby, they're still undertaking a service. He asks the question, does the position change because they are in fact carrying out social care for tasks for part of their time? And then says this, Mr. Justice Higginbottom did not think that it did. He concluded the responsibility is not, quote, is not diminished, etc. And then this sentence, although it is true that he adopted the care home's view of the proper construction of Section 59, this conclusion seems to me to have been reached irrespective of his analysis of that section, and simply by focusing on the duty of the health authority under Section 3, particularly when read with Regulation 18. And so what we infer Lord Justice Elias is referring to there is that it doesn't matter how you interpret the Act generally, because in context, Section 49 can only be applied one way. When we get to Lord Justice Lloyd-Jones later, he disagrees with Lord Justice Elias's starting point. But actually, the starting point is correct in our submission. And the reason it's correct is that what one is doing here is saying, well, it doesn't matter how you interpret Section 49, generally or more generally in different contexts. What does matter is once you accept that there is a service within the meaning of 49.2, how can it be other than needed to be provided by a registered nurse? So that's our first proposition. The second proposition, moving to interpretation, the Court of Appeal...
Was your submission in the court below the same as or different from that of Lord Justice Elias?
Our submission in the court below was the same as Lord Justice Elias, but what we had not done, subject to one exception, what we had not done was separate out the case into interpretation and application. But it was the same in the sense that our position has always been where a nurse is in a nursing care home, that nurse is undertaking the service of being on call to provide health services throughout that time. That's always been our submission. And it was that central submission that led or that founded Lord Justice Elias's analysis. The only difference where we part company very slightly is in a realm almost of academia, because, as I shall come on to later very briefly, Lord Justice Elias referred to so-called marginal costs. There was no evidence about any marginal costs. We don't accept that was well-founded because we say the statute says nothing about marginal costs, but that is what I will call later a wrinkle, and it really doesn't matter for the purpose of the central analysis.
No, there's nothing to suggest that it costs more to have a nurse there combining her nursing care, whatever that may mean,
Yes.
with social and personal care, whatever that may mean,
Yes.
than it does to have her just doing the nursing care and then being on standby for the rest of her time.
That's right. There was no evidence about that at all. And we say, A, there was no evidence, and B, the statute doesn't envisage that kind of apportionment. But that's a small point.
I mean, is your point that when one comes to section 49 too, one doesn't get on to the other than bit because it's accepted that this is a nursing service, that her being there 24 hours is a nursing service?
It almost comes to that. It doesn't quite come to that because obviously one has to look at the accepting words. But what we say is, once you accept that it is a service, it cannot be other than needed by definition. Because if one only has to ask the question, why is the nurse there? Why is the nurse required to be there? Answer, to be on call, to meet health needs as and when they arise. That is the service. So once you define the service, you rob the accepting words of needing further interpretation. That's the point. In other contexts, however, I can well see that the accepting words might have more bite, and that raises the interpretation question of, well, what do they mean in other contexts? To which our answer is a very simple answer. It will depend upon the context. What you can't drive the analysis through is the fulcrum of language, which is what the Court of Appeal did, the majority, in fact, what they all did.
I thought that's what we spent all our time doing.
Well, it may be,
when we're
but it's the
interpreting
wrong approach in
statutes.
this case. And the reason it's the wrong approach in this case is that it leads to, if you try to apply a tourniquet of, needs can only mean tasks, it falls down. It falls down syntactically for a start, because what that means is that you are collapsing a service into a task. So even on the level of syntax, it breaks down.
Is
But
that, is that another proposition that you've got?
It's one of the arguments in support of the second proposition.
Well, yes, don't come out of your course, because it makes it much easier for us to understand your argument if you
Your
divide
Ladyship
it
has
up.
heard our first proposition.
Yeah.
The second
Yes,
proposition.
so I suppose you could say, however, I'm going to take you out now, and you will tell me if I'm doing it. You could say that there might be a registered nurse who happens to be employed to do no nursing care
Absolutely.
in a care home.
That's right.
For a variety of reasons. It may be a bit artificial, but it would nevertheless be. And if you have a registered nurse who's employed to do a job that involves no nursing care, well, then the care home pays.
Yes, if the purpose
Or the
of
local
the nurse,
authority pays, or the self-funder pays, yes.
our argument, and this is actually down the line under proposition 2, but our
Yes.
argument is that when we are talking about services needing to be provided, we are talking about a status-based or role-based use of language. In other words, why is the nurse there?
Well, role is better than status, isn't it, because of the example I've just given you?
It is. The role is better. It's just that Parliament used the word status, but it doesn't really matter because The role of the nurse. Why is the nurse there? That's the question of interpretation. Why is the nurse there? Answer in context one, has to be there to provide healthcare 24 hours a day when it's needed. Answer in other contexts, well, that may depend upon why the nurse has been put in what is her role. But the role, if the role is, for example, as does I gather happen in some homes, to be a manager of a care home, then she's not there in the role of registered nurse, she's there in the role of manager. And we think it's helpful to think about the question of interpretation. I appreciate I haven't articulated Proposition 2 yet, as role-based. And so this is our second proposition, if I may just read it. Secondly, the Court of Appeal erroneously held that as a matter of general interpretation, Section 49 requires an atomization of the specific tasks performed by a registered nurse. Rather, it is a role-based as opposed to a task-based provision. This is demonstrated by three indicators. One, the structure and wording of Section 49. Two, the real-world practical consequences of interpreting the section in any other way. And three, the government response to the Royal Commission report, and to the extent that there is any interpretative ambiguity, the unequivocal ministerial statements in Hansard. And so obviously I have to come to those three indicators, and I appreciate that I'm slightly contradicting myself, that when we get to this point we are looking at language and so on, but what we do say is that interpretation is easier once you understand the context application in Proposition 1. And then finally, something which we hope we might never need to worry about, but it is our third proposition. Even on the logic of their own case, the local health boards carried out a legally erroneous method of calculation in respect of personal social care, paid breaks, and time receiving supervision. And that is founded essentially on a paragraph in the judgment of Lord Justice Elias. And I'll come to that later, right at the end, if I may. Well, can I start then with Proposition 1 and seek to develop that? We say that nothing is needed to understand or to follow this in terms of all the detailed case law, legislative provisions set out in the various cases, other than Section 49 and the relevant regulation and one piece of evidence. So the key statutory provision is Section 49. The court knows, hopefully has read it and reread it, but it's cited at paragraph 15 of our case. Memory stick page is 770, 770. And I will, if I may, take the section as read, but make certain points about it. And so it's convenient at this stage. I'm not going to go into any detail of interpretation at this stage, but it's perhaps helpful to pick up from the wording 2 points briefly relating to interpretation, both picked up by Lord Justice Elias in paragraph 47 of his judgment at memory stick page 211. If I can assume that the court has the section in front of it, the first point is simply this. Section 49, subsection 1, contains the relevant funding prohibition. It is set out in broad terms, as Lord Justice Elias found, so as to prohibit the provision of nursing care by a registered nurse in or in connection with the provision of any such services. So we at this stage, but this is, I appreciate, an interpretation point, we at this stage lay stress on the words or in connection with, which does suggest that the prohibition is intended to be more expansive than a simple task-based proposition. The second early construction point at this stage, also detected by Lord Justice Elias, Section 49, subsection 2, then this is the definition of nursing care by a registered nurse, and the positive part of the statutory definition uses the word involving. And We say that the word involving is suggestive of the fact that healthcare is integral to, though not exhaustive of, a service falling within the general definition of nursing care by a registered nurse. We see the word involving cropping up again and again, and we'll see it later when we get to the government's response to the Royal Commission report. In connection with involving, they are broader, they are not rigidly prescriptive. But that's section 49. I should say that it has been replicated in its essentials in the 2014 Act. The 2014 Act I'm not going to take the court to unless you want me to, but it's in manuscript pages, memory stick pages 798 to 799 in Authorities Bundle 1.
Wouldn't you also point to the words in section 49 to any services?
I would.
Involving the provision of care not being restricted
I
to
would.
a particular type of care.
Yes.
It really boils down to what the words from other than to registered nurse mean, doesn't it?
It does. But one has obviously to look at the structure of the section and pick up...
The whole case depends upon the construction of the proviso, doesn't it?
I'm sorry,
The
Madam.
whole case depends upon the construction of the proviso.
Well,
So we can't stop it before we get to other than.
no, you can't. I'm not suggesting you should. What I am suggesting is, when I get to interpretation, I appreciate, when you read section 49, you can't avoid, I'm afraid, getting slightly entangled in what I call the more general interpretive question, but I'm going to come to that secondly. But what I do say is that just picking up that early language starts to give us some clues. What I'm really going to rely upon is not only the structure, but also the practical effects of construing section 49 as the majority of the Court of Appeal did, and then also what we say the obvious legislative intent was. But I'll come to that later if I may. So that's section 49 on the one hand in relation to this first proposition. And then, if I may, moving to the regulation, we set out at paragraphs 31 and 32 of our case the statutory provenance of the regulations. I don't think it's necessary to go through those, but perhaps it is important to go straight to the regulation, which is in the Authorities Bundle 1, tab 12, and its memory stick pages 815, but particularly at 817. 817 is where we find Regulation 18.
But it's all set out in your case, isn't it? It's all set out in your case.
It is. That's why I'm not going to go through it in great detail. But as far as Regulation 18 is concerned, which again, your Lordship's absolutely right, it is set out in our case. The words we highlight for this purpose is the registered person, this is in Regulation 18.3, shall ensure that at all times a suitably qualified registered nurse is working at the care home. What we would say about the structure of Regulation 18.1 and 3 is that they are separate obligations, but the obligation to provide the relevant service of being on 24-hour call is the same under both. Every care home must have at least one registered nurse on site at all times under Regulation 18.3. But where the care home has more residents whose health needs can only be met by having more than one nurse on 24-hour call, then a failure to have the appropriate number of registered nurses on site at all times for that purpose would be a breach of Regulation 18.1a.
Is there any definition? Sorry. Is there any definition anywhere of nursing?
No. Any more than there is the definition of service.
I think I was going to query, you're saying every care home under Regulation 18.3
Yes.
needs a suitably qualified registered nurse working at the care home at all times. I thought it was only a care home which provided nursing, not all do.
No, your Lordship's right. If I have stated the proposition loosely, I didn't mean to. It's nursing care homes. That's what I meant.
Yep. No, there is no definition anywhere in any of the community care legislation which differentiates between nursing care homes and care homes.
No. This all arose, and I'm sure the court knows this, from the gradual erosion of that which the NHS must provide. We start off with hospital care. We move through the Cochrane case into a primary need for healthcare, and then we move into the lesser healthcare needs, but still very important healthcare needs, which is why I talk about the complex, unpredictable nature in a nursing care home. And then we move down the scale to non-nursing care homes. I suppose you might get a nurse in a non-nursing care home. It would be a different context. But that's not the context we're in here, as my Lord Wilson has said. And I just again go back to the concession. This is the point at which to record it, having dealt with Section 49 and mentioned the regulation, that it is indeed clear and common ground that being on 24-hour call is a service within the meaning, not just a service, but a service within the meaning of Section 49. So our respectful submission is that once that is accepted, there is no appeal against or attempt to withdraw that concession. The Court of Appeal recorded it and proceeded on that basis. Once it is accepted that in a particular context, and I do accept it's a particular context, a specific context, there is a Section 49 subsection 2 service, then by definition, in our respectful submission, this is coming to my Lord Carnwath's point, by definition, it needs to be provided by a registered nurse. Because it's the nurse, it's the registered nurse in her role, his or her role, as a registered nurse, whose presence fulfills the Regulation 18 requirement, or the Regulation 18.3 or 18.1, of carrying out nursing care by a registered nurse. The local authorities are therefore statutorily prohibited from funding it, and that is the entire context in which nursing care is provided in nursing care homes. It's a very simple argument, but it's, in our submission, the right starting point, rather than the starting point of just looking generally at the words in Section 49. Let's look at it contextually, see where that takes us. And we say context is central to the application of Section 49. And where does that lead us in terms of the analysis? Well, it leads us surely to saying the first thing you have to do in a nursing care home under Section 49 is to identify the relevant service. The Court of Appeal hardly ever get into service, they get into task. But that collapses the question. The question is, what is the relevant service? How do you identify it? Secondly, you look to the nature of the service and you look at the circumstances in which it's provided. Again, just an application of the words of Section 49 and indeed of the accepting words. And finally, the last question in this analysis, one asks the question, is that service needed to be provided by a registered nurse? To which the answer is, once you've got to the definition question, it must be, in our respectful submission. An essential feature of nursing care homes is that they have to be staffed at all times by a registered nurse or proportionately suitable number. So the fact that health needs of this kind, of this particular kind, can arise at any time is perhaps a truism, but it is in any event confirmed by the defendant's respondent's evidence. And I would invite the court to look briefly at manuscript page 504, which is paragraph 8 in the witness statement of Victoria Warner, who is a witness for the respondents. And about halfway down paragraph 8 of Miss Warner's statement, Miss Warner, I should say, we find this at 501, is the clinical board nurse, primary community intermediate care for the clinical board at Cardiff and Vale University Health Board, the first defendant in these proceedings. Halfway through paragraph 8, in general terms, those requiring nursing care from a registered nurse will have needs that mean that they need to be cared for in an environment where a registered nurse is available on a 24-hour basis. This will usually be because of the complexity, intensity, or unpredictability of their needs. And that is the respondent's evidence, and it is absolutely aligned with the legislative requirement. That's why we say that not only legislatively, not just a question of the tail wagging the dog, but in practice, that is why they are there. That is the context in which they are there. And point really here, which is why it's so important in our submission to differentiate application from interpretation, is that there is only one answer to the question we ask in this context. Now, the fact that there is only one answer that can be given does not mean that there is a distortion somehow, an interpretative distortion of section 49.2, which talks about nature and circumstances. Administrative lawyers, and no doubt your ladyship and your lordship, are used to provisions which talk about nature and circumstances, and that usually gives rise to the thought, well, that just depends. That just depends upon the subjective evaluation of the public body. That's not this case. This case, in this context, requires these words to be applied one way. That's the point. And that's why application is important here in understanding why there are some contexts in which, although there's a general provision talking about nature and circumstances, there is only one answer that can be given.
So, I mean, I was saying that the nature of a nursing service in this particular context is that it needs to be a 24-hour service.
Exactly. And that stems from the axiom on which the whole judgment proceeds and the concession made. But that doesn't mean, and this is really the point, that does not mean that nature and circumstances is so broad that there might be another answer in a different context. But our case is concerned with a specific context. And so we submit that our analysis, and that is our analysis, is reinforced, and indeed not only reinforced, but confirmed by the analysis in the dissenting judgment of Lord Justice Elias. And may I...
Now, just be clear, I mean, I understand how you apply that to the one nurse who has to be there under 18.3.
Yes.
How do you get it to apply to other nurses beyond the one?
My Lord, the answer to that is 18.1 and 18.3 of the regulation have to be read together. And it's the point I made, hope to have made a few minutes ago, which is that the obligations are separate, but effectively what it comes to is that you've got to have at least one nurse present 24 hours a day, and proportionately, depending upon the number of residents with healthcare needs of that kind, more than one nurse. That's the combined effect of 18.1 and 18.3. There is a further...
You don't have any evidence of that.
No, but it's a legislative requirement, my Lord.
I can see what the regulation says, but you relied on the evidence of Mrs. Warner for the one nurse.
Yes.
Well, we have nothing which sort of ties that into what...
No, because that will depend. I mean, obviously, the number of nurses that are needed for 24 hours will depend upon the assessment of the health boards as to what the healthcare needs are. I accept that. But there is a further point, which I can come to later, which is the point made by Lord Justice Elias. What about overstaffing? So what about you have more nurses than are needed? Well, the answer to that is that falls outside the role contemplated by Section 49. Section 49 is talking about a role that is needed. So all we are relying upon is the proposition that in a nursing care home, where registered nurses are provided in their role to meet healthcare needs at any time of the day, that is a relevant service. There is only one answer that can be given to the nature and circumstances point, and it is that that is to be funded by the health boards. I will come to these points, such as overstaffing, in a moment. But what we say is that our analysis, and as I say, that is our analysis in essence, is confirmed in the judgment, or by the judgment, of Lord Justice Elias. And if I can just break that down a little bit so that the court knows what we're saying about the stages of his analysis. So the starting point in our submission is to be found at paragraph 44 at memory stick page 210. And this is where Lord Justice Elias identifies that which has in fact been conceded. But it's a very succinct articulation of the concession. Paragraph 44, and these are the words on which we place stress. Even though the registered nurse will be spending some of her time performing social rather than nursing care, at least one qualified registered nurse, and possibly more, depending on the requirement for nursing services, that's my answer to by Lord Lord-Khalmer's point, will need to be in the care home at all times to cater for nursing needs as and when they arise. So that's the service. And then Lord Justice Elias turns at paragraph 47. Section 49 is widely drafted and clearly designed to ensure that all aspects of nursing care fall outside the responsibility of the local authorities. And Lord Justice Elias picks up three specific points in that paragraph of construction. The first point is the principal purpose of the section is to identify a concept of nursing services that a local authority is not even permitted to provide or therefore to pay for. His second point is, interpretative point, the concept of nursing services is wider than that of nursing care, and that's quite important. And thirdly, a local authority cannot provide this wide meaning of services, nursing services, even indirectly. And then at paragraph 54, the conclusion that flows from those two stages, given the accepted effect of the regulation, it follows that none of the costs of employing a registered nurse to be present at all times should be borne by the local authority. And then, paragraph 55, what happens if they're doing nothing? Well, Lord Justice Elias says, under Regulation 18.3, it's necessary to secure the presence of registered nurses as part of the arrangements for providing nursing care. They need to be on duty and ready for action even when they're doing nothing. It was conceded that when on standby, this was a concession made, the local health boards must foot the bill. The position does not change. We then have to go to the next paragraph to see this as well, because they are carrying out social care tasks for part of the time. And says Lord Justice Elias at paragraph 56, this was the conclusion reached by Mr. Justice Higginbotham. It was not necessary to accept the claimant's interpretation, this is the point I made earlier, of section 49 to arrive at that conclusion. Indeed, this is the point. Lord Justice Elias disagrees with our construction more generally, but accepts the application in this context. Such conclusion, says Lord Justice Elias, was open to Mr. Justice Higginbotham simply by focusing on the local health board's duty to make healthcare available, especially when read with Regulation 18. And our respectful submission is that it is at this point, although Lord Justice Elias is not articulating in quite this way, that he is distinguishing between the particular application of the section and the more general questions of interpretation. And then at paragraph 60, it follows that subject to the payment of any marginal costs, I'll come back to that point shortly, I quote, the local health board must make and pay for in full all the arrangements necessary to secure the provision of the requisite nursing care by registered nurses. And we say that neither Lord Justice Elias nor we are relying upon the 2002 regulations to interpret section 49. That's not what we're doing. But we do say that Regulation 18, 1 and 3, is highly material to understanding the way in which the Act applies to nursing care homes that are regulated through these regulations. We say that the flaw in the majority judgments in the Court of Appeal is that whatever the correctness of their other conclusions, they never engaged with or grappled with the fact that in the context of a nursing care home, we are dealing with how the concession is to be applied. And that is why we say that Lord Justice Laws was wrong to say, as he does at page 207, paragraph 31, that, and I quote, the respondent's case, that was us at that stage, and with respect the judge's conclusion, rest upon a non sequitur, and that it does not follow from the fact that a nurse has to be on call at all times that everything she does on duty is to be treated as a service which needs to be provided by a registered nurse. And we say that the flaw in that reasoning is that it fails to engage with the point that even where the nurse is carrying out a social care task, she is still performing the overriding service of being available to meet healthcare needs. And the learned Lord Justice's assertion here of a supposed non sequitur, we say, stems from the fact that he is confusing the application of Section 49 in a particular context with a more general question of interpretation of the words of the section in a different context.
I wonder about that. I mean, it seems to me that to say that application gives the answer, you don't need to look at interpretation, faces the problem that if the interpretation is correctly task-based, then the application doesn't give the answer. If it's service or role-based, which is the assumption that you're making, then maybe it does. Well, but to say that you need to look only at application in order to determine what I understand the dispute to be between the party, is it task-based or is it role-based, doesn't give an answer.
But let me not rest the case on a binary distinction between interpretation and application. Let me simply say that if you get to the point where you accept that being on call to meet healthcare needs is itself a service, it's not easy to see why that service isn't needed. Perhaps that's a better way of putting it.
Yes, I think it is, yes. I mean, if you're right that it is service or role-based, then the application gives an answer in your favour because of the concession. But the decision we have to make, is it task-based or is it service-role-based?
Yes, I accept that. Now,
I think we've got to look fairly carefully at what this concession means. We know that Miss Morris made a concession, for example, about standbys, a standby time.
Yes.
So that was a limited concession.
Yes.
Read one way, the concession as encapsulated by Laws LJ in the final sentence of paragraph 16 is a concession of the whole issue.
Absolutely.
And it would be odd if Miss Morris was conceding the whole issue.
In a sense,
so I really think that at some stage, with the help of everybody, we've got to unpick what she did or did not concede. Well, I suppose whatever she conceded is not the end of the story.
Well, I was going to pick up your Lordship's last words. It's not the end of the story. I mean, I'm not going to rely on our argument on a concession. What I am going to say, however, is that the Court of Appeal recorded the concession very clearly. And so they get themselves into a problem once they reason on that basis.
So will your answer be the same, concession or no concession?
I'm arguing that the concession as recorded is an important tool for deconstructing the analysis of the majority of the Court of Appeal.
Well, we are interested in answering the question.
Of course.
We're not really interested in picking apart the reasoning of the Court of Appeal.
My lady, I think it's important, though, because, and the reason I respectfully submit it is important, is that when you read the reasoning, you begin to understand what's gone wrong. And so if I may just spend 2 or 3 minutes on it, no longer. If you go to paragraph 32, page 207, Lord Justice Laws refers to, quote, other difficulties. And he says the other difficulties are these, that in disavowing the application of the statutory prohibition in a case where a nurse is self-evidently not understanding nursing tasks, as, for example, where a registered nurse is managing a care home, this demonstrates that we are necessarily driven to accept that, quote, the touchstone for the application of the accepting words is the actual work being done by the nurse. Now, that's a very important sentence in our submission, because what it shows is it is a distortion, I'm sure an unconscious distortion, of the statutory language. Because the touchstone for the application of the words in section 49 is an examination of the service and not of the work that the registered nurse is providing, the circumstances in which the service is being provided, and whether persons in a particular context need the provision of that service. So a person doesn't have to be a registered nurse, a point made earlier by my Lady Hale, to provide the service of managing a nursing care home. But she does have to be a registered nurse performing that role to be able to provide the service of being on 24-hour call to meet complex, intensive, and unpredictable health needs as and when they arise. So what we say is revealing here is the collapsing, that's what a point I made much earlier, in the Court of Appeals analysis between service and task. Of course, if you say, as your starting point, that a service can only be a task, you've answered the question one way. But once you accept that the word used in section 49 is not task, but is service, then we have 2 points. First of all, service is never defined. But secondly, it falls to be interpreted in a real-world context. And if you interpret it any other way than we suggest is the correct interpretation, you will get into unworkability problems. And I'm going to come to that later, but...
It's not only service, it's any services.
Exactly.
So I'm not sure whether there's a nuanced difference between any services and service.
Well, there may be. It may be reinforcing the point I'm making, that what we're not solely considering here, or shouldn't be solely considering, is task. If you start with task, you're never going to get into context at all. Now, you may say, well, where's the suggestion in the Act that we ever get into context? Answer, this is a question of statutory interpretation that has to be applied to real-life situations. And so we do say this is, as a matter of syntactical analysis, the Court of Appeal is collapsing the word service, or any services, into a series of atomized-based tasks. And secondly, they're ignoring the context in which the problem arises. Now, that is a genuine interpretation question, but the application point I mentioned earlier takes us right back to, well, let's see how it operates in a concrete situation. Let's see how their analysis operates. And as I shall show later, they all recognize it doesn't work in the real world practically, but they say we're driven to this conclusion by our interpretation.
And here, I mean, it's of some importance that the section is not concerned with simply an accounting exercise. I mean, some of the arguments seem to suggest that really it's a matter of how you allocate the costs.
Yes.
Whereas actually what the section is directed at is telling the respective authorities what they can and cannot arrange for
Yes.
or provide. And so it's slightly counterintuitive to think that the care home is able to say, well, I can arrange for you now to take the lady to the toilet, but I can't arrange for you to be on standby when she doesn't need to go to the toilet.
Exactly.
Which rather supports your view. One's got to look at it a little more broadly and see what is the nature of the service in general and not what each little task is done, or you get an impossible... I mean, this is really the argument that's put, is where it becomes rather...
Roger puts it helpfully at a stage earlier. You're making the arrangements. What on earth are you going to do? Is your arrangement going to be, well, you can spend 10 minutes on standby. You can't spend 10 minutes on standby. You can do this and that. It just doesn't work in the real world. And this is the point that as I say, each of the judgments in the Court of Appeal recognise this in different ways. But they say, just to quote, as I say, Justice Lloyd Jones, well, the tail mustn't wag the dog. But it isn't wagging the dog. We are not approaching it from regulation.
Well, you say it's really just an illustration of how the thing must work in practice.
Exactly.
Because you can't have a nurse who's sort of half the time doing... who's in and out providing a service.
Yes.
In fact, he needs to be the whole time on duty.
Exactly. And the other thing is this. I mean, I was going to be slightly flippant, but I mean, the point is a real one, that if a nurse has to, for accounting purposes, keep some sort of track record, as the point made by Lang and Buisson in their report, of the minutes spent on standby, the minutes spent doing this or that or the other, one starts to wonder what quality of care is being eroded by this paper exercise. It is simply not envisaged, we say, by the statute. Paragraph 119 of our case, we set out the points made by Lord Justice Lloyd Jones. I don't think I'm going to spend much time on those. Your lordships have them. But essentially, we say each of them are flawed. We're not using Regulation 18 to interpret. We say it's quite telling, perhaps, that if you go to paragraph 70 at page 216 to 217, we see in that paragraph 70, Justice Lloyd Jones disagrees with the starting point taken by Lord Justice Elias. And that, I think, again, we say is revealing, because the starting point of what is the service here in practice must be the correct question to answer the question, what is the service and is it necessary? To start with something different, the abstract words of the section, is not helpful. And to say as he does, as Lord Justice Lloyd Jones does at paragraph 77, that it would defeat the policy, our interpretation, underlying section 49, is just a question beggar, because you've got to go to the legislative purpose and you've got to go to the words. Ultimately, you can only use the words and decide what they mean and how they should be applied. Can I deal very briefly with the marginal cost point? We deal with this at paragraphs 126 to 128 of our case, and the very simple points we make there are that the statute says nothing about marginal costs, as my Lord Carnworth has just mentioned en passant. This is not really an accounting exercise statute. That's not what it's about. And there's no evidence, perhaps most important of all, as to any marginal cost. So it's a kind of theoretical construct, possibly into which Lord Justice Elias was driven by the fact that he was agreeing with the majority. But at the moment, I don't understand how marginal costs enters into this appeal at all. Can I therefore move to our core proposition 2? And my Lord Hodge has already indicated, or will draw from me, the implicit concession that one can't entirely separate these two issues. I do accept that. But our case on Proposition 2 is again fairly simple. Proposition 2 raises the question of how to identify a statutorily relevant service being provided by a registered nurse. Now, I've already taken the court to the passage in Lord Justice Law's reasoning at paragraph 32, where he substitutes the word work for service, and that we say, as I said, is a revealing error. We say that in order to determine what service the nurse is providing, as opposed to what work the nurse is doing at any specific point in time, it is simply necessary to ask the question, why is the nurse there? What role is the nurse playing? Now, answering that question in that general way in which I've just attempted to do, in the context of nursing care homes, we say provides reinforcement for our arguments on the first proposition. Because if you apply the question to the nursing care home, why is the nurse there? Answer, unless there's overstaffing, it's designed to meet healthcare needs. But there may, we accept, be different answers according to the context. But the question, the context question, will always be, what is the purpose of the presence of a registered nurse in a given context? And we say that as a matter of practical common sense, if a registered nurse is in a particular setting to provide specialist care that only a registered nurse can offer, the fact that she may be doing other ancillary tasks, or perhaps doing nothing at all for certain periods, does not mean that all the nurse's time does not, as it would in any NHS hospital, fall to be paid by the NHS. All that the nurse is doing other than providing the service of treating patients within the scope or an ambit of the National Health Service. And this is the point, your ladyship anticipated me by about an hour and a quarter, where I say we are not dealing here with a technical factual dispute between public bodies. This is a real question of importance for the service user, because if it's a community care service, that is chargeable, subject to means. So that's the real importance of this case from the patient's point of view. And we say that it is simply counterintuitive to suppose that registered nurses, when they are there qua their status as a registered nurse, have to atomize and record their time as the respondent's analysis mandates, almost second by second. It is the essence, I know this is the point my instructing solicitors want me to make, it's the essence of a registered nurse's role to treat on a continuous, holistic basis.
Is everything that a registered nurse does when in a hospital things that can only be done by a nurse?
Well, yes, if we're right. The nurse has to be there to perform.
Well, if you're right,
yes.
The answer is yes.
Yes.
But if they're right, the answer would be
you
no.
wouldn't get community care services, as far as I'm aware. Your ladyship may say
No,
wrong.
I'm just thinking about the tasks. What do people do for people who need looking after? Some of those things are things that you can only do if you have a particular professional qualification. Other of those things are things that other people can do. Do nurses looking after people in hospital only do what only nurses can do?
No.
I would be very surprised if the answer to that question
Must be no.
was,
But that's why we're right, not what we're wrong. Because a nurse will be there
I wasn't making any suggestions to who's right and who's wrong. I'm simply trying to
One's always looking,
get
though,
my
for the-
head round this
looking for the
extraordinary,
dagger.
extraordinary attempt to parcel up the different things that you do in relation to somebody who is, to a greater or less extent, dependent and vulnerable and needs some looking after.
That is our real point. Our real point is this, that what all this was about was to remove the anomaly that you get free NHS care in a hospital when a nurse is looking after you. But when a nurse is looking after you in the community, or rather in a nursing care home because of your health needs, you're paying for it. And so this is why I come back to the point that the service user is at the end of the tunnel the funder, if the other side are right. Now, the question comes down to, what is Section 49 aiming at? Is it either a technical accounting section, or is it a section which is synonymous when you use the word service with tasks or work? If it is, it's a surprising and counterintuitive conclusion. We have the concession that where a nurse does nothing, a registered nurse does nothing in the care home but stand by, he or she is still performing the service. But it just cannot be that, I mean, just to take the most absurd example, that they are doing something because they fetch a glass of water, or they do something which, if it fell within Section 21 of the National, Section whatever it was of the National Health Service and Community Care Act, would be a social care service in different context. They're still, in reality, acting as a nurse. And you pay for the nurse's time in fulfilling that function. So the only alternative to our approach, of course, is the approach adopted by the Court of Appeal, but that approach deprives identification of the relevant service of context altogether. It never asks that question, and it simply asks what a registered nurse is doing at any specific temporal point. And it's that approach, rather than ours, which we say is monolithic in its application, because it always collapses services into tasks. That's the inevitable effect of the argument. So, on that approach, we would ask, forensically ask, what touchstone is there for identifying a service? The only touchstone is, what is the nurse doing at point X, point Y, point Z? And it simply is unworkable. And that is the real flaw in the Court of Appeal's approach in our submission. It misinterprets Section 49 by simply finding that, presumably, in order to constitute a service, it requires a nurse's time to be broken down into the individual tasks.
Well, it's obviously unworkable in the sense that, in practice, it doesn't happen.
Well,
in practice, they don't ask in relation to each individual nurse working in a care home, how is her time divided? They do it on a flat rate basis.
yes.
So they clearly have done a general management consultant's exercise of working out averages, but you could have a care home where the nurse spends almost all her time, or nurses spend almost all their time on nursing tasks, but you get the same amount of money for that nurse as you do for one where a lot of her time is spent doing other things. So it's obviously unworkable in fact.
Yes. Well, that's the point. It's unworkable in fact. It's unworkable because in order to make it work, in theory, you have to account for or work out some form of touchstone for what is health and what isn't. And I'm not going to go into this at any great length, but the court will have seen the Langham-Buisson report, which makes very interesting reading. I'll just cite one or two passages in it. And we have the Court of Appeal itself recognizing that in the real world it doesn't work. But we say there are three specific indicators, that even taken singly, let alone in combination, reinforce the proposition that Section 49 is role-based and not task-based. And the three indicators are, first of all, the structure of Section 49 itself. I've made a few preliminary points about that. Secondly, the impracticability that I've just mentioned. And thirdly, the government response to the Royal Commission report, and to the extent that there remains ambiguity, the what we submit to be the clear and unequivocal statements in Hansard. It's quite illuminating, at least if my memory is correct, to find Miss Morris for the respondents now saying we shouldn't be using Hansard, when Hansard was precisely what was relied upon in front of Mr. Justice Higginbottom by the respondents. In the course of the hearing, it became clear in our submission that Hansard supported our case and not that of the respondents. But I'll come to Hansard later. So may I start with the structure of section 49? And there are 6 very short points we make about structure, most of which I've mentioned already.
Where do we find that in your case?
Well, your lordship will find it at paragraphs 90, not in quite this way though, but 94, 95, and 96. But I haven't put it in the 6 short points, so perhaps I can just do that. First of all, section 49 can I just give your lordships the passages in the 2 judgments that we rely on? The first 3 of these 6 points are picked up in paragraph 34 of the judgment, or in the judgment of Mr. Justice Higginbottom, memory stick page 235, and in paragraph 47 of the judgment of Lord Justice Elias, memory stick page 211. So first 3 points are Mr. Justice Higginbottom's points. Point 1, section 49 subsection 2 is not defined simply as it could easily have been in terms of tasks that only a registered nurse could undertake. And if it was as simple as that, why didn't Parliament say so, is really the point there. Point number 2, section 49 is not defined simply as it easily could have been in terms of the provision of nursing care, but rather in terms of all care. I think this is your ladyship's point, any care, subject to the accepting words. Point number 3, section 49 is not defined simply as it easily could have been in terms of the provision of that care, but rather in terms of services involving the provision of care, point I made at the start. Point number 4, now we're coming on to Lord Justice Elias's points. The principal purpose of section 49 is to identify a concept of nursing services that a local authority is not even permitted to provide or therefore to pay for. Point number 5, the concept of nursing services is wider than that of nursing care. And last point, a local authority cannot provide this wide meaning of nursing services even indirectly. Now, the Court of Appeal's reasoning on structure was to different effect, and in the majority judgment of Lord Justice Laws, he essentially said this. First of all, paragraph 29, page 207, memory stick page 207. The accepting words of section 49, 2, contemplate a distinction between services which need to be provided by a registered nurse and those which do not. And then what we submit to be the non sequitur. This requires a task-based approach, taking account of the nature of each task and the circumstances in which it is performed. I'll come to each of these points in a moment, though. Second point, paragraphs 20 and 35, at memory stick, respectively, pages 203 and 208. The local health boards have a discretion under section 3, subsection 1 of the 2006 Act to decide which tasks need to be carried out by registered nurses and which do not. Point number 3, paragraph 31, memory stick page 207. It does not follow from the fact that a nurse has to be present at all times in a care home, pursuant to Regulation 18, that everything she does on duty is to be regarded as a service. It's a question of fact, whether any given task performed by the nurse needs to be performed by her. And finally, paragraph 32 to 33, memory stick pages 207 to 208, the two explanations given by the care homes for the accepting words were misconceived. So we say, first of all, that we do not ignore the accepting words at the end of section 49. Our interpretation gives at least two meanings to the accepting words. First of all, the local health boards are protected against paying for roles which are staffed by a registered nurse, but which could as equally be staffed by a non-nurse. And it is the case on the ground that some care homes employ registered nurses as managers. We don't say that would fall within section 49. Similarly, this is a hypothetical example, a junior nurse may be recruited as a care assistant to gain experience. It's just another example we've thought up. Without the accepting words in section 49.2, the health boards would be required to fund the costs of these roles. And Lord Justice Laws suggests that this is an acknowledgement of the very proposition which the respondents seek to repudiate, because the care manager won't be doing nursing tasks, because the touchstone for the application of the accepted words is, quote, the actual work being done by the nurse. The flaw in that objection is that he's conflating work with service. A simple conflation of words. He is assuming the truth of that which he is seeking to demonstrate. And secondly, we say, and this is a point I think I gave in answer to my Lord Carnworth, the accepting words prevent the local health boards from having to pay for overstaffing. They reach a judgment as to how many nurses are needed to meet the health needs. The care manager puts in far more. The local health boards don't have to pay for overstaffing because the role of a registered nurse is not needed. So we respectfully submit that Lord Justice Laws was wrong to say, at paragraph 33, memory stick page 208, that overstaffing didn't fit the statutory language. The key word, we say, is need. Lord Justice Elias rejected our overstaffing explanation on the ground that it couldn't account for the situation where a nurse is surplus to requirements but is providing a service which requires the skills of a registered nurse. But that is wrong once it's appreciated that we are talking about a role-based provision. The nurse who is there and surplus to requirements is not performing a role that is needed in the context of, in which it arises, needed to meet health needs. And so, finally,
Sorry, I don't quite understand how surplus provision can arise.
It shouldn't arise.
Well, the local authority is not permitted to employ surplus nurses to do nursing tasks.
Not at all. No, I agree. The health authority will be making a judgment about how many nurses are needed. So if you go over that, it shouldn't arise at all, is the point. Because overstaffing is not something which is a service for which the role of a registered nurse is needed.
So you're relying on the circumstances in which the particular services are provided?
Absolutely. Yeah. And finally, the suggestion by Lord Justice Laws, paragraphs 20 and 35, memory stick pages 203 and 208, that the boards have a discretion under section 3 to distinguish between those tasks which need to be provided and those that do not, we say is illogical with respect. We say that it is illogical to say that the local health boards have a discretion to decide what the statute means. As a matter of principle, any given task either falls within the meaning of nursing care provided by a registered nurse, or it does not.
It's certainly very odd that the statutory discretion of one public authority should be used to define
The obligations.
And powers of a completely different local authority.
That's exactly the point we made to Mr. Justice Higginbottom. It would have extraordinary effects. So we certainly do make that point.
But it's very difficult anyway, isn't it? Because the regulation requires the care home to determine what's needed
Yes.
in terms of competent staff and so on. But they're prohibited from providing certain types of staff under Section 49. So even if their judgment is that certain staff is required, then they can't do it because that judgment is given to the health authority.
In terms of the health needs that are required, I agree. But the idea that the health boards can reach a conclusion that affects the meaning of nursing care provided by a registered nurse is the point that I'm concerned with.
Of course, the care home providers are the people who are under the obligations in Regulation 18.
Correct.
And indeed the equivalent but rather vaguer obligation in the English regulations.
It will then come down to a
But
funding
what
question.
Section 49 is about is what the local authority is empowered and obliged to fund, isn't it? So that they are two separate things.
Exactly, they're two separate questions. That's why we part company with Lord Justice Lloyd Jones, who said the obligation lies on the care homes themselves. That doesn't answer the question. That doesn't answer the funding question. Now, in the respondent's case, we understand 2 points to be made about the structure of Section 49, and I'll just give a brief response to each. First of all, in the respondent's case, at paragraph 7a, it is argued that the phrases nature and circumstances does not have to be provided by a registered nurse, must have a meaning and function. We agree with that, but the meaning and function, we say, requires them to be used to identify and to analyse the service that's being provided, and the service will differ according to the context. And so we don't agree that the mere appearance of these words, as the respondent asserts in the same paragraph, quote, requires them to be interpreted as distinguishing between the different tasks carried out by a nurse. And we say that is a non sequitur, demonstrated by the omission in the very words used by my learned friends of the word service, that has to be identified by reference to some relevant touchstone. And secondly, we come back to the discretion point, which I think I have already dealt with. The question is not where there's an overlap and the NHS is the primary decision maker. That answers the question. The question is, by what principle is the relevant service to be decided? So that's the respondent's case on structure as we understand it. In terms of the Secretary of State, a number of points are made, and I'll try to deal with them very briefly. First of all, paragraph 12a of the Secretary of State's case, a statement, slightly anodyne statement, that the clue is the plain meaning of the words used. Well, we agree with that. But unfortunately, the formulation at paragraph 12a of the Secretary of State's case again elides the concepts of services with tasks and appears to treat them interchangeably for the purpose of his plain meaning argument. So that analysis, we say, goes nowhere. Secondly, paragraph 12b, the Secretary of State suggests that we are using Regulation 18 as the determinant of the meaning of the statutory words. Well, we say that's wrong for the reasons I've given. Then the same error, paragraph 12c, where the Secretary of State criticises Lord Justice Elias for doing the same thing. The Secretary of State states correctly, we agree, you can't use Regulation 18 to interpret Section 49. We're not doing it, and Lord Justice Elias wasn't doing it either. Fourth point, the Secretary of State erroneously suggests that our interpretation is at odds with decided case law, and somewhat strangely, from my purposes, Grogan is mentioned. I was in Grogan, so I can certainly confirm and respond to it if necessary, that Grogan is completely irrelevant to the issues in this case. Mr. Justice Charles never had to decide, never heard argument about the true meaning of Section 49, but his analysis, if anything, helps us for reasons I could come to should it become even theoretically relevant. Paragraph 12e of the case, it is said, well, we must be wrong, because, for example, the NHS would have to pay every time a nurse takes a patient to the toilet. Well, yeah, that is our case, and we don't see any anomaly in it. for the reasons I've given. Paragraph 12F, it suggested the interpretation would produce a windfall for local authorities, to which the short answer is if a nurse is performing the function of being on call, she is performing a relevant nursing service. There is no windfall to the local authorities. 12G, the Secretary of State does concede that some social care tasks may fall within the statutory definition, but seems to say there is some kind of boundary line. But we say this is a false approach, the premise being that Section 49 relates to the funding of individuals. It doesn't, it relates to roles, which is why it's unproblematic for the local authorities to fund a manager role in a care home, even if the manager occasionally provides cover for nursing care. And finally, 12H, it's argued that the word nature refers to the inherent qualities of the relevant service. Well, that's only true to the extent that one has identified correctly the relevant service. The mere assertion, if that's what it is, that the word nature is to be assimilated to a task begs the whole question to be decided. At paragraph 97 of our case, we deconstruct an argument that hasn't been advanced in the case of the respondents, so I'm not going to deal with it, but I refer you to it, where Ms. Morris took a point that the word, I think it's the word services was plural, so therefore must mean tasks. We infer that point is not being pursued, but if it is, we answer it at paragraph 97 of our case. So those are our points on structure. Now I now move very briefly to impracticability. The second indicator that is, in our submission, of really telling in this case, relevant to interpretation, is that the Court of Appeal's task-based interpretation is impracticable, we say, to the point of being unworkable in the real world. Lack of practicality is something that we suggest, with respect, the Court of Appeal came implicitly to accepting, but felt was the inevitable consequence of its interpretation of Section 49. So can I just take the Court to those paragraphs? First of all, in the Judgment of Lord Justice Laws, memory stick page 208, paragraph 35, second sentence, Mr. Gordon has rightly underlined the practical difficulties in finding an answer. So rightly underlined that. His doing so only serves to emphasize the truth. The question is one of fact, not law. We respectfully disagree with that statement. Then moving to paragraph 51, memory stick page 212, in the judgment of Lord Justice Elias, 5 lines down, the word beginning however, the care homes and the local authorities can point to the fact that the exercise of distinguishing between nursing and social care tasks is in practice, as Lang and Buisson recognized, a highly artificial one. Indeed, the Lang and Buisson report observed it would be a lot simpler for the LHBs to provide the full salary cost of registered nurses rather than arguing about the split between nursing and non-nursing care. And then at page 216, paragraph 66, in the judgment of Lord Justice Lloyd Jones, second sentence, I think, the difficulties of such a process have been identified in the Lang and Buisson report and are no doubt considerable. Clearly, it would be much simpler for the LHBs to provide the full salary cost of registered nurses employed to provide care in care homes, thereby avoiding any needs to argue about the split between nursing and social care. However, in my view, a task-based approach is required by the governing statutory provision, and the fact that another approach might be more convenient cannot justify a departure from it. So they're the passages which we respectfully submit illustrate the difficulties of the respondents' and Secretary of State's interpretation. And as I said earlier, and I repeat the word, the approach of the majority of all the Court of Appeal, actually, generally, is monolithic. It imposes a straitjacket of words, supposed meaning of words, actually not analysing the meaning of the words, because service is the key word. Need and service are the key words.
I mean, he accepts there that it's appropriate to employ reasonable and informed estimates.
Yes.
Where does he get that from?
I don't know, because there's nothing in the section that indicates, as this is your lordship's point earlier, that it's an accounting exercise. The point really is it's a prohibition, and we say
Prohibition on doing something, not on putting some accounting treatment.
yes, it's a prohibition on funding essentially, but it's not a provision which is meant to be worked out in terms, we say, in context of trying to work out what actually is the specific sum spent on specific tasks. Indeed, it would make nonsense of the prohibition. It would make the prohibition legally very uncertain. I mean, this is a criminal offence, and so the idea that Langham Buisson can take the view that the offence is committed in circumstance A, and some other health board can take the view, well, no, it's not that, it's B. Langham Buisson say in their reports, and I'm sure that the court's read it, that well, it's arguable that this falls within the prohibition, this doesn't. I mean, this is terrifying for a statutory prohibition that is dealing with liability for crime. So we say it's not just impractical, but it is unworkable, and it is not the design of Parliament. That's why we say if it comes to it, we really do need to look at what the legislative intent was, and not say, well, as Lord Justice Laws does, we never get into that because it's rather a strained, your construction is rather strained. Now, it's quite interesting this, because when one goes, if I could ask the court briefly to do this, to memory stick page 208, I should have just made one point. The criminal liability does not rest on the local authorities. It rests upon is it the care homes?
Yeah, well, reaching the regulations.
Yeah, on the care homes reaching the regulations. If I could ask the court to look at paragraph 35, page 208, where after accepting that we rightly raise the point that the interpretation leads to practical difficulties, Lord Justice Laws concludes by stating as follows, quote, "The fault in the respondent's argument is that it seeks to replace this practical," we would respectfully substitute the word impractical, "process with an appeal to legal definitions." Now, this is in our submission an error, because the fact that the immediate case was about the application of Section 49 in a specific context does not and did not mean that we are all resorting to the tourniquet of rigid legal definition to support the correct interpretation of Section 49. It is, in fact, we respectfully submit, the other way round. The interpretation arrived at by the Court of Appeal applies the tourniquet of impracticability and unworkability to what should be a context question of application of the statutory language. Now, I'm not, because of time constraints, I have to finish, I know, at 20 to 1, that's the clock for me, but I'm therefore not going to go through the Langham Buisson report, but I'm hoping that I can take as read the passages that are in it. For example, paragraph 98 of our case, Langham Buisson, I can give the court the references, "This was always likely to prove challenging. The complexity of the analysis, together with areas of potential unreliability for the future, beg the question as to whether this approach is sustainable." Now, I should say, the approach that Langham Buisson were questioning the sustainability of was the approach that the health boards had laid down. And it concluded by saying, memory stick page 655, "Would it not be a lot simpler just for the NHS to pay the full direct salary cost of registered nurses rather than argue about the split?" Now, of course, that doesn't determinatively answer the interpretation question, but we do say that the practical difficulties of that kind are a very strong reinforcing indication that Section 49 was not intended to require a nurse's time to be atomized in the way envisaged by the local health boards. And an intended hard-edged statutory prohibition. Can I just go to a Hansard statement for this point, and I'll come back to Hansard admissibility, all the rest of it. But at memory stick page 1360, column 431, Mr. Hutton talking about the bill, I won't take you to this in the bundles yet, but he said this: we want to provide absolutely clear definitions and a clear boundary in relation to who pays for what under the arrangements. The alternative is not one that any of us would want to embrace: confusion, uncertainty, and a lack of clarity about who has responsibility for funding which element of a person's long-term care. So whether I'm entitled to make that point, we will see when we get to Hansard, but it cannot have been intended, even as a matter of ordinary statutory construction, that a definition causing such uncertainty could have been intended, we say, by the parliamentary draftsman. And the second point, the obvious point again, but worth reinforcing on this question of practicability, we know that on the ground this is going to be very hard for nurses to follow. The best example we found in the bundles is memory stick page 608, which I'll just go to that very briefly. Yes. I'm not surprised that splitting nursing and personal social care is proving difficult. This is the subject of ongoing professional debate, and for many, the definition of nursing should include physical, social, emotional, spiritual elements. But that's not helpful for a financial modelling perspective, I know. So I won't labour that one.
Sorry, where are we finding this?
608. Memory stick page 608. It's an email from Linda Chandler, who I think is David in Langham-Buisson, is replying to Langham-Buisson. So she's with the health boards, I think. So I'll just read it again. I'm not surprised that splitting nursing and personal social care is proving difficult. This is the subject of ongoing professional debate, and for many, the definition of nursing should include physical, social, emotional, and spiritual elements. But that's not helpful. Rare moment of candour. That's not helpful for a financial modelling perspective, I know, so I won't labour that one. And we'll bow to Rob's expertise. However, I agree that frontline nurses will struggle with the differentiation. These points are not made to win the case on detail. They are made to illustrate, and this is one of many illustrations in the bundles, how impracticable and unworkable this whole definition is.
And clearly, Langham-Buisson struggled with the differentiation.
They did.
I'm not sure that frontline nurses had much struggling to do, or would have much struggling to do,
With what their
if your
task is.
appeal was to fail.
If the appeal failed, I think they would, because the boundary between what one might call healthcare and social care is not a clear one. I mean, it really isn't clear.
But how does that boundary affect them in their day-to-day work? I think that's Lord Wilson's point.
Well, it doesn't, but the whole point is this, really, that if a nurse is providing what I think the Royal College of Nursing would call holistic care, they wouldn't be atomising their time at all, yet they've got to do it if, in fact, there's going to be a sensible accounting exercise.
Well, have they got to do it? Because the point I made earlier about a flat rate having happened.
Yes, but this is what happened in the
Are
present
people
case.
actually... I suppose that's how the Langham-Buisson report was constructed.
Yes.
Sort of hour-by-hour exercise. Actually, it'd have to be minute by minute, wouldn't it?
But no one is suggesting that nurses in care homes have timesheets where they record every 30 seconds or every 3 minutes. Are they doing healthcare? Are they doing social care? I mean, I simply don't see where this impracticability point arises.
Well, can I take the court very briefly? This just may not be the best example, but memory stick page 614. I know that your ladyship will say, well, that's how they did it, but it may not have to be done like that. But it's quite instructive, this. So we've attached, this is, as I understand it, the continuing exchange of information between Langham-Buisson and the health boards. Halfway down 614, we've attached FNC, Funded Nursing Care Survey information, one-page introduction to explain the importance of the survey, nurse time analysis guide, important to provide the examples to particularly show nurse activities which are delegated, mentoring for which is still nursing time, and contrast this with very limited routine personal care which would be excluded, etc., etc.
So basically, for the purpose of doing their task, they had to do a survey of what nurses did.
In order to reach the question
In order
where
to reach-
liability
Yes.
fell. Absolutely.
In order to answer the questions that are being put to them. But of course, that wouldn't be the case in the future or all the time. It's just the way they did their survey.
I've been given another reference, and I'll come back to your ladyship's point. Page 628, we see the nurses' time analysis form, which is just worth a brief inspection. But I struggle, and perhaps it's my fault, I struggle with the idea that in the absence of clarity as to what work is purely specialist nursing work, that can be answered clearly in this or any other case. And therefore, you face the problems of inconsistent application, uncertainty. It isn't possible to reach a clear view, a universal view on that question, if the answer to it is, it's got to be task-based, because not only have we got to identify the nature of the service, well, that's quite easy, the service is just a whole lot of tasks, but you've then got to identify and deconstruct and unravel the nature of each and every task to see whether it falls within the definition. And that's where the problems come.
The problem is, it's, as Lang-Buisson's report shows, it's a very artificial exercise, and in many cases they were doing what the health boards told them to do when they didn't think it was the right answer.
Yes.
And secondly, there may be inconsistency between different health boards who instruct different management consultants who use different techniques. Exactly. So the impracticality is gaining a coherent approach to this boundary across the jurisdiction as a whole, exactly, rather than any impracticality for the nurse at the coalface.
Oh, yes. Yes, I'm certainly not saying that the nurse won't be doing this. Yeah. In the real world, the nurse will be doing the nurse's work. But
I think that's what we were trying to say.
But I agree with that. But that doesn't answer with respect the construction point, because the construction point depends upon applying plain words, and the plain words include the words service, need. It has a totally easy application if it's context-driven, role-based. It has an impossibility of clear application if it is task-based. And the problem is there is a liability, criminal liability here on the care home manager. So one really has got to, at the end of the day, the funding that is prohibited has to be able to be clearly defined. And it can't be clearly defined on the respondents' and Secretary of State suggested approach. That's the practical difficulty. I'm certainly not relying, although it's quite, in some ways, forensically entertaining to go through Lang-Buisson, but I'm certainly not saying because they did a survey that answers the interpretation question, because they had this uncertainty. I'm saying there is an uncertainty right at the heart of this. I'm not going to go through it. If the court goes to our case at 62, 63, and so on, going right through, I think, to 76, that deals with the nuts and bolts of what happened with Lang-Buisson, but I appreciate that may not be central to what this court has to decide. It is worth, for a bird's-eye view of this whole question of impracticability, though, worth going to paragraph 60 of the judgment of Mr. Justice Higginbottom, which is to be found at memory stick page 242, where at paragraphs 53 and 54, he sets out quite succinctly the problems on the ground. But I won't read that now. It's just perhaps a useful reference point. May I turn finally on the list of indicators to the Royal Commission report and ministerial statements. I should say that each of these points, we say alone, demonstrates that our submissions on construction are right. And taken together, they are, in our submission, respectful submission, overwhelming. But now we get to the Royal Commission report and the ministerial statements. So I start, if I may, with the legislative history, and we say the legislative history, I don't mean going right back to Cochrane, I'm simply going to start with the Royal Commission report. But we say that that history is relevant, and we cite, in our case, Bennion, and I'll just give the reference, if I may, and then read the citation without taking you to it. It's Authorities, Volume 2, tab 34, memory stick page 1427. And the citation is, the interpreter cannot judge soundly what mischief an act is intended to remedy unless he or she knows the previous state of the law, the defects found to exist in that law, and the facts that caused the legislator to pass the act in question. Now, in general terms, our case under this part of this indicator is that the intention of Parliament in enacting Section 49 was to transfer responsibility from the local government to the NHS for funding the full cost of the work done by a registered nurse, qua registered nurse, in community care settings, subject to the exception contained in the second part of Section 49.2. And that's what explains, of course, our point on context. And this then would match the position in hospital where all the work performed by a nurse would be free at the point of delivery under the NHS. So the government's response to the Royal Commission report, which the 2001 Act was based on, stated this, and I'll give the court a reference if I may. I'm going to the response, however, first. It's at paragraph 93, I think, of our case. The people identified as needing nursing home care will no longer have to meet any of the costs for the registered nurses involved in their care. Now, can I again highlight that the word involved here surfaces again in Section 49, suggesting a broader view given, certainly by the government, to the idea that a registered nurse's role was what was important. Now, that statement of principle, we find it, I think, at paragraph 2.10, so memory stick pages 1326 to 1327 for that particular quote, the citation. But if that is followed through into the legislation, it surely shows that it is inconsistent with a task-based approach. And indeed, in the old days, as Lord Justice Laws notes at paragraph 5 of his judgment, the local authorities were liable to pay, subject to means testing, for the full cost of care home residents who qualified for assistance under Section 21 of the National Assistance Act. But in March 1999, the Royal Commission on Long-Term Care published a report. This is, I think, set out in our case, so I'll give you the reference so you can follow it. Paragraph 39 of our case, I think, says this. And Mr. Justice Higginbottom describes its findings. It's quite useful. Paragraph 26 of his judgment, memory stick page 232. However, from 1983 to 99, the number of NHS long-stay beds across England and Wales, so this is the long-stay hospitals that led to the Cochrane case ultimately, declined by 38%. So this is all in the name of, I think, community care. A loss of 21,000 beds, whilst the number of private care homes beds increased by 900%, an increase of 121,000 beds. Of the additional private care home places, only 8% were paid for by the NHS. The NHS therefore made very considerable savings, but it was recognised that some of the relevant costs had simply been shifted to local authorities and other elements of the social welfare system. So this is, I suppose, what we all, those of us who practiced in this area, recognised as the sleight of hand when community care came in on the 1st of April 1993. As Mr. Justice Higginbottom records at paragraph 30, page 233, memory stick, the Royal Commission's main recommendation was that all reasonably required nursing and personal care should be available free of charge to those who needed it. So then we get the Royal Commission conclusion, which is to be found at memory stick pages 1274 to 1275, and the key paragraph is paragraph 6.22. And this is the key recommendation, subject to dissent. So at present, said the Royal Commission,
So where do we find that?
I'm sorry, it's memory stick pages 1274.
It's in your case.
Paragraph 41 in your case set out verbatim.
It is set out verbatim, yes. Yes.
It's much easier to use your case.
That's why I said, when I was coming to this, I think I mentioned that you could follow it in the case. It's paragraph 41. So at present, if a person receives nursing care,
I'm
that is
sorry,
care.
I would like the reference to the Royal Commission's report, please.
Yes, I'm sorry, my lady, I thought I'd given it. It's
1274.
It's 1274
Thank you very much indeed.
to 1275. And it's paragraph 6.22. In fact, I can give you, just see. Yes, the Royal Commission report itself, if I just give this to your ladyship, is at tab 29. It starts at MS page 1252.
Thank you.
And I've given the later citation simply because that's the relevant paragraph.
Yes, thank you.
And then the government response, you might find helpful, begins at page 1316.
Yes.
But just reading paragraph 6.22, at present, if a person receives nursing care, that is care which involves the knowledge or skills of a qualified nurse, either in a nursing home or a home which is registered to provide both nursing and residential care, he or she has to pay for the nursing care as part of the home's fees, subject to mean testing. If, however, comparable care is delivered in a hospital or community setting, it's completely free to the user. This state of affairs is not justified or defensible. It would hardly be acceptable to begin charging for nursing care in hospital. The right way forward, therefore, is to abolish charges for nursing provided in nursing homes and dual registration homes. We believe this should be done. Now, there is a direct parallel between the hospital scenario and the nursing care home scenario. And we say it's, of course, we have to look at the statute, but it's a clear statement of the starting point of the Royal Commission. And what the Royal Commission further concluded, we see this at paragraph 42 of the case, is that the additional cost of being looked after arising from frailty or disability, personal care, should be funded by the state. So effectively what the Royal Commission was saying was A, nursing care should be funded by the state, but when you separate personal care, community care services, that should also be funded by the state. And as the judge records, there was a dissent in the Royal Commission report. That dissent is recorded in paragraph 43 of our case, and it is at memory stick page 233, paragraph 30. I won't go through it in detail, but the key point for present time purposes is about just over halfway down. However, the dissenters define nursing care narrowly as that care which requires the specific knowledge and skill which only registered nurses can provide. This is Mr. Justice Higginbotham referring to the dissent in the Royal Commission report. So, a dissent based on what is now said to be the correct interpretation of section 49. We then move down the page in the case, paragraph 44. The United Kingdom government responded to the Royal Commission report in July 2000, and we can find that paragraph 6.37 and 6.43 following of the report, and the pages of the memory stick 1277, 1279. And the response rejected the recommendation, the government's response rejected the recommendation that personal care should be state-funded, and to that extent agreed with the dissenters, but it accepted the recommendation in relation to nursing care. And I won't read those paragraphs. Well, perhaps I should. 2.5. Firstly, we will make NHS nursing care free in all settings.
Could I have this page, please, again? Sorry.
Yes, it's 1325 to 1326.
1325.
Firstly, we will make NHS nursing care free in all settings, ending the present unfair situation where a minority of people in nursing homes pay all or part of their nursing costs. 2.8, there can be no justification for charging people in care homes for their nursing costs. We will make nursing care available free under the NHS to everyone in a care home who needs it. It will require primary legislation, and we will introduce this as soon as possible. Fast forward, of course, to section 49. And then we say at paragraph 45 of our case, the government adopted, however, a wider definition of nursing care than that proposed by the dissenters. So they adopted a wider definition than the respondents say is the definition encapsulated in section 49. And the reference page for 2.9 and 2.10, memory stick pages 1326 to 1327, 2.9, in the future, the NHS will meet the costs of registered nurse time spent on providing, delegating or supervising care in any setting. This is a wider definition of nursing care than proposed in the note of dissent in the Royal Commission report, which suggested it should include those tasks that only a registered nurse could undertake. 2.10, the key paragraph in our submission. Therefore, people identified as needing nursing home care will no longer have to meet any of the costs, note the word any that comes up in section 49 later, for the registered nurses involved in their care or for the specialist equipment used by those nurses. Instead, the NHS will meet these costs. People who can afford to do so will still have to make a contribution towards their personal care and accommodation costs.
So what's the distinction there? What's personal care referring to?
Well, I think it's referring to the rejection of the suggestion that community care services should be funded. In other words, where a local authority is providing community care services, let's say under 117 of the Mental Health Act, for example, that was not going to be provided free. But what was certainly being said here is that the concept of nursing care was, if you like, parallel to that which is currently provided in hospitals.
I wonder if you can, in all fairness, bring this within the Benyon criterion. I mean, Benyon tells you that you can look to these things to establish the mischief. This isn't the mischief. This is the government's statement of its solution to the mischief. The mischief is the lack of level playing field between the NHS hospital, the nurse who goes on a domiciliary visit, and the care home. That's the mischief. And what the government was doing was wanting to create fairness so that the NHS would pay for nursing. That much we can take from the past, but on what legal basis can we use paragraphs 2.8, 2.10 to construe what was eventually passed by Parliament?
Well, can I just show your Lordship, not just the Benyon citation, but just in case it assists on this point, the case we handed up this morning, which should have been included in the bundles, and I hope you've got it, loose. Attorney General's reference number 1 of 1988.
Yes, I have it.
I think it's one appeal case is 971, and it's at 980 that I think I was essentially looking at. So it's at E to H. I don't know whether this takes it wider than Benyon, but I would hope that it might.
980 E to H.
980 E to H. So we had our attention drawn to the history of the Act. Its effect was to consolidate earlier enactments, including the provisions of the Companies Act, was itself the subject of amendments. Preceding the Act was a white paper on the conduct of company directors. We are invited to look at the contents of that paper in order to see the mischief which it was designed by Parliament to remedy. As Lord Diplock pointed out, such papers may be used to resolve the ambiguity in favour of a meaning which will result in correcting these deficiencies in preference to some alternative meaning that will leave the deficiencies uncorrected. The justification of this use of such reports is that knowledge of their contents may be taken to be shared by those whose conduct the statute regulates and would influence their understanding of the meaning of ambiguous enacting words. So we said that principle is wider than Benyon, and actually is what it shows is that an official document such as this, such as a white paper or the government response, which is put out for public consumption, may be used as an aid to statutory interpretation in appropriate cases.
Yes, but you have to, in order to identify the deficiencies, so again it's referring back to the mischief. If the mischief is the absence of the level playing field, then on the one hand you have on that playing field the hospital, and on the other hand you have on that playing field the domiciliary visit. Now, if you create a level playing field between the hospital and the care home, that points towards you. If you create a level playing field between the domiciliary visit and the care home, that points against you. So again,
I'm not quite sure. Yes, I'm sorry, my lord.
Because the nurse who goes in will be providing nursing services and presumably leaving it to others to cook meals and do things like that.
Well, my lord, in our submission, first of all, as a matter of principle, it can be used as an aid to construction. If I think your lordship's point may be, well, maybe that's possibly true, but maybe the content here doesn't help. That's a slightly different point. We say that this is relevant to construing ambiguity because the overall clear intention from the response It's not so much the level playing field, but it is actually a directly focused provision aimed at avoiding service users having to meet the costs of a registered nurse's time. But so 2 points. First of all, we say it is irrelevant in terms of an aid to construction, provided always it aids construction. If it doesn't, then of course it falls. And secondly, we say it does aid construction here for the simple reason that the legislative purpose is directed towards the service user. It's not directed towards a level playing field as between the NHS and the LHBs. It's very much, the statements show it's directed towards the service user.
But I question whether the Attorney General's reference takes you any forward from Benyon, because at the start of the paragraph at letter G, we were invited to look at the contents of that paper in order to see the mischief which it was desired by Parliament to remedy.
Yes.
You weren't being asked to look at the paper to see what the remedy was.
No, but the mischief is the anomaly whereby service users have to pay for their care in one service but not in another.
Yes.
I mean, that's the answer. Whether it's right or not, that's what we say.
Thank you.
So, Mr. Justice Higginbottom at paragraph 31, pages 233 to 234, made it clear that, from his reading, it was the case that in respect of nursing care to be provided free of charge to residents in care homes, the government intended to include more than those tasks that only a registered nurse could undertake. Indeed, it intended that residents, and by extension, the local authorities, should not have to meet any of the costs of nurses involved in their care. That responsibility was transferred to the NHS. And it was brought forward, coming back to the mischief point, paragraph 47 of our case, to remove the anomaly identified by the Royal Commission. I appreciate there's a distinction between remedy and mischief, but we say that falls away in the context of the points we make here. We also refer to the explanatory notes, paragraph 48 of our case, and the reference for that, if you want it, is memory stick page 1419. We cite it at paragraph 48 of our case, intended to strengthen the incentives to ensure effective rehabilitation after acute illness or injury, estimated, etc. Removes the right of a local authority to provide or arrange nursing care by a registered nurse. Now, whether we're right about interpretation is important, because the way in which the Court of Appeal dealt with it, we find at paragraph 34 in the Judgment of Lord Justice Laws, page 208, memory stick page 208. He really dismissed this in one line by saying that material of that kind cannot in principle be deployed to support a strained construction of a statute whose ordinary meaning is unproblematic. Now, whatever the reasons for accepting the points we make on relevance or rejecting them, this is not a good reason in our submission, with great respect. To suggest that the suggested interpretation is strained is to deny the very ambiguity that we respectfully submit exists and that needs the material to be invoked. And the rationality of it is reflected in our submission, the ambiguity, rather, is reflected in the thoughtful reasoning of Lord Justice Elias when he says one interpretation is this, another interpretation is this. Well, and we also suggest that the government response is clear. Lord Justice Laws also held in the paragraph I've cited, paragraph 34, that the statutory words didn't reflect the government proposal. Well, we'll come to the statutory words, but the government proposal is pretty clear, and we say is encompassed only in an interpretation of section 49 that is role-based rather than task-based. Can I then turn to the related point of admissibility of Hansard before going briefly to the Hansard statements? As far as ministerial statements in Hansard are concerned, this was fully before the Court of Appeal, but it wasn't addressed in the judgments. And we infer, however, I suppose it's a bit like getting a two-judge divisional court with each judge disagreeing. We infer that had the Court of Appeal given thought to this, it would not have resorted to Hansard in view of its reasoning in relation to the parliamentary materials. So we take it as a negative, but I just make the point that there's absolutely nothing in the judgments about it. We respectfully submit that the ministerial statements are admissible aids, query whether they satisfy the test, I'll come to that in a moment, they are admissible aids, according to the criteria laid down in Pepper and Hart, set out in paragraph 53 of our case, very familiar to this court. So we say, first of all, the legislation is ambiguous, and that is demonstrated by the fact that it's plainly capable of more than one interpretation. C, and this is the paragraph I was mentioning of Lord Justice Elias, paragraph 52, memory stick page 213. He said he does not find the section happily drafted. He also refers to the competing arguments, the competing interpretations. He talks about the alternative construction. Now, we say that the ambiguity that those parts of the judgments reveal is reflected by the fact, although not proved by the fact, that Section 49 has been interpreted in 3 different ways by 4 judges in these proceedings. The underlying reasons, however...
Each of whom thought it was perfectly clear what it meant.
I know. But isn't that
always the problem that we have.
But the underlying reasons, we don't just say, well, 3 judges disagreed, therefore it must be ambiguous. And Mr. Sheldon rightly criticises us, or maybe it's Ms. Morris, or maybe both, for saying that. Our underlying reasons for submitting that Section 49 is ambiguous are, first of all, the word services, not in our submission addressed separately in the Court of Appeal analysis at all. That is central to our task-based interpretation deconstruction. It's not defined, it's not assimilated to a task, it's not assimilated to a series of tasks. Secondly, the meaning of the requirement to have regard to the nature of the service and the circumstances in which they're provided cannot be said to be obvious. So we say that the fact that 3 judges have disagreed is a good forensic jury point, and it's not a bad starting point, but it's not the answer. The answer is this provision is genuinely ambiguous for the reasons that I have indicated. We also say, although we're not going as far as to say that it satisfies the second limb of the first test in Pepper and Hart, but that would lead to unworkable consequences. But we do say we come close to that because the results on the ground add to the problems of ambiguity. We also say that the second and third criteria in Pepper and Hart are satisfied. We say the parliamentary statements couldn't be clearer, and that leads me to look at what the Secretary of State does. He spends some time in his case, paragraphs 53b to 57, exhorting the court to look at the context in which these statements were made, presumably designed to show that they were not clear. But there is one very important point that I should mention in relation to the Secretary of State's deconstruction, because the foundation for his deconstruction, see paragraph 53b, is they rely upon the very same paragraph of Mr. Justice Higginbotham's judgment on which we rely. So it's perhaps just worth picking this point up. The paragraph of Mr. Justice Higginbotham's judgment is to be found at memory stick page 261, paragraph 128.4. Now, unless I have misread what is said by the learned first instance judge, he did not say what the Secretary of State is saying he said. So what the learned judge is said to have said by the Secretary of State, paragraph 53b, is Mr. Justice Higginbotham rightly referred to the relevant passages of Hansard as ambiguous. That's what's said, he said. In fact, what we respectfully submit was said by Mr. Justice Higginbotham was this: I consider most of the statements in Hansard to which I was referred, I think he says to be unambiguous, but I think he means ambiguous. However, it comes as some comfort that in the course of the Standing Committee E, and then he cites the very passage in Mr. Hutton's statement on which we rely. And so we say that what Mr. Justice Higginbotham was there in fact saying was, I don't have to go to Hansard, but one of the passages I certainly do regard as unambiguous. Now, that's a possible misreading by me, but that's how I read what he is saying there. But can I now, so we do say that therefore these statements are admissible. The question is, are they, I mean, we also say they're clear. That's the really important point. So just going through them very, very briefly, paragraph 92 of our case, if it's easier to follow in our case, Mr. Hutton, the Health Minister, said during the passage of the bill through Parliament that, quote, the clause as we have drafted it does not involve a list of tasks. I can give your lordships and your ladyship the reference. It's memory stick page 1367, and it is column 444 of Hansard Standing Committee E. I'm going to go through these quickly because I've only got 5 minutes. Paragraph 49, we say the statement on which the learned judge relied at first instance and the statement on which we place primary reliance demonstrates that the Health Board's explicitly task-based approach did not accord with the legislative intention. Indeed, it's difficult to think, we would suggest, of a more unequivocal statement in the context of a dispute about whether the proper interpretation of Section 49 is task-based than what was said by Mr. Hutton. He's at columns 431 to 432, memory stick page 1360. He said our definition, and I interpose the words, of nursing care is wider, not narrower, and goes beyond the definition proposed by the minority report by the two commissioners who signed it, in that it provides a more expansive definition of what nursing care involves. Our definition is not task-based. Paragraph 50 of our case, Mr. Hutton also said a nurse is not defined by tasks. He went on to give what we say is an obviously non-exhaustive example of a service which would fall within the definition of nursing care by a registered nurse. We picked that up in the case, and the reference is authorities memory stick page 1366. A nurse is not defined by the tasks that he or she performs, but by skills and expertise. She may take someone to the toilet, and then it goes on. What I want to say about that example is this is perhaps more equivocal than the one I've cited at columns 431 to 432, but the example of the nurse who takes a patient to the toilet to check that patient's mobility shows clearly that the government did not consider that a nurse's role could be spliced up into individual tasks. That's the point of that. Tellingly, a citation I've given your lordships, your ladyship and your lordships already, to be found at memory stick page 1360 and 51 of our case, the definition point, intention to provide clear definitions. And finally, paragraph 52 of the case, the government rejected an amendment whereby nursing care would be defined according to the type of care, not the person who delivers it. Reference for that, column 419, memory stick page 1354. So we say that if you look at the three indicators, let alone the specific context in which this appeal is concerned with, there is the strongest case to support our interpretation and not that of the respondent and Secretary of State. The very last point only arises, this is proposition 3, only arises if we're wrong in our main arguments, either core proposition 1 or 2, and it is the erroneous method of calculation in any event. May I indicate that it is to be found, this argument, in paragraphs 122 to 124. I can give some references very briefly in a moment. I want to make the one point here, however, orally, that it is said that this argument is inadmissible. I'm going to let the respondent develop their arguments as to why they say it's inadmissible. The simple answer to it is it's not inadmissible because Lord Justice Elias had held that these categories had been wrongly excluded. See paragraph 57 of the Court of Appeal judgment, memory stick page 214, and we relied on Lord Justice Elias's reasoning in our appellant's notice. See paragraph 16, memory stick page 28. And if I can give the court some references, we have at paragraph 123 of our case 3 categories: personal social care, first footnote after non-nursing member of staff, referring to the witness statement of Alexandra Kelleher. Memory stick references 592 to 593. Memory stick referring to overall holistic person-centred plan. The footnote there refers to memory stick page 635. Underpaid breaks. The correct reference there, arguably all time on breaks ought to be treated as nursing care. Memory stick page 648. Next, footnote, time spent receiving supervision. Memory stick page 648. And we say at paragraph 124, these specific points were not addressed by the majority of the Court of Appeal, but they were raised in our skeleton, and Lord Justice Elias also raised them. My Lord, my Lady and my Lords, in the last minute that I think I have, if I don't, then I'll stop. We simply ask the Court to allow this appeal.
Thank you very much, Mr. Gordon. Ms. Mackenzie? You're coming next, Miss Morris.
I am. Lady and my Lords, this case concerns the identification of the boundary between health and social care in a particular context, namely the provision of funded nursing care in a care home. We propose to advance our submissions in the conventional way, namely to look at interpretation first and then application. In relation to the context, there are three key aspects of it which we would draw to your attention at this stage, particularly bearing in mind the way that they have arisen in the course of argument already this morning. The first one is the overarching or underlying statutory scheme which sets down the division between health and social care more generally. And that's the obligations on local authorities under Section 21 of the National Assistance Act and the obligations on the NHS in these circumstances under the NHS Wales Act. And I'm going to take you to that in more detail in a moment. The second aspect of context, which is important, is that we are here concerned with funded nursing care in a care home. And as my lady has already adverted, that's of critical importance to service users as it is to health and social care bodies and indeed to us in our analysis. And it's important to understand how those people who receive funded nursing care in a residential care home fit into the structure. At one end of the spectrum, there are people who are in hospital, and of course they get all their care from the NHS. But also, aligned with them are those people who are entitled to what's called continuing health care. So those are people who are cared for in the community, but who get 100% of their care needs met by the NHS. And broadly speaking, they're people who have care needs where it's said that their primary need is for healthcare.
Well, those of us who were involved in the recent case about the jurisdiction of the Court of Protection understand that because...
Precisely. But in the light of perhaps my lady's comments about people who are receiving nursing care and what a nurse does, I consider it might be helpful just to bear this in mind. And in fact, it's set out at the judgment of Lord Justice Laws at 197. At the other end of the spectrum are people who don't need any nursing care and they only receive social care. But the analogy that's perhaps most hopefully identified, I think, comes from my Lord Hodge, which is that the person who receives funded nursing care in a care home is very much in a similar position to somebody who is living at home, receiving social care at home, but for whom, for example, the district nurse comes in so many times a week.
Well, this in a way is part of the question, is it? If it was to level the playing field, if you level it with hospitals, well, you certainly get everything that a nurse does, you get free. If you level it with the community, you get everything that the nurse does free, but it may be that the community nurse visiting you at home is more focused solely on what you might regard as nursing tasks, whereas in a hospital, a nurse might do things which you might not regard as nursing tasks.
Milady, we'll develop this point in due course, but what's important is not to, perhaps to borrow one of Mr. Gordon's words, collapse funded nursing care into continuing health care. Because a person who has a primary health care need gets all of their care, whether personal care or social care, funded by the NHS. But a person who gets funded nursing care has been identified within the scheme laid down by Parliament as only requiring a certain element of healthcare, and it's important that that shouldn't then expand so that then there isn't.
Yes, but you've got accommodation and food and everything else, so I'm not sure that this
but
really
maybe,
helps us with what we mean by nursing services.
The third aspect of context is this, and it's in our case at page 126 and 127, and it deals with the practicalities of how the calculation ended up being created in this way. Now, you'll see that the Section 49 was enacted in 2001, and originally responsibility for shouldering the financial burden of funded nursing care was with the National Assembly for Wales, as it then was. And it carried out perhaps a more rough and ready, but not totally dissimilar exercise to that which my clients have carried out at that stage. And you can see over the page in our case at 127 that it came to the conclusion in the early noughties that the average amount of nursing care required by a resident in a care home who was entitled to funding nursing care was 7.5 hours per week. Now, between the early noughties and the date of our decisions, there were rumblings that this somehow wasn't right or wasn't enough or ought to be reviewed. And in response to all of that, the exercise that you see before you in the Langham-Buisson report was carried out. And the conclusion of that exercise you have at paragraph 15 of our case, which produced an analysis that on average, those individuals who were entitled to funding nursing care needed 7.62 hours. So it was a decision to give more than had historically been the case. And it's fair to say that the methodology is one that had existed for a very long time without criticism until we made a decision to give them more. Turning...
That's a wonderful point.
Perhaps I should sit down now then.
I'm not sure it helps us at all. But
it's perhaps, if we're talking about context, it's perhaps helpful to bear in mind that, this is the approach which has been uncriticised.
It may explain why you appealed.
Deep sense of grievance. Then, in terms of the way in which we propose to frame our submissions, first of all, we will deal with interpretation. And the first aspect of that, we say, is the words of the section. We say the words of the section do indicate that a line must be drawn between different things which are done by a registered nurse, call them task, service, what you will. It's the differentiation which is critical. Secondly, we say that that differentiation has both a task and a role element. It's not either or. We say that deciding which side of the line something falls on is a matter of fact and may sometimes be even a matter of judgment. We say there's nothing inherently objectionable in that inherent element of uncertainty, and it doesn't compel us to adopt the approach advanced by Mr. Gordon of essentially alighting upon one factor, the existence of Regulation 18 or the need for someone to be present, and it involves looking at the entirety of the situation. And we say if you look at the entirety of the situation, then yet further, it will produce an answer which is identical to that which was given by the Court of Appeal and which we advanced before you. We say that this interpretation of Section 49 is vitally consistent with the overarching statutory scheme as between Section 3 and Section 21. And it's consistent with the way in which the courts have looked at the boundary between those statutory schemes in cases like Cochrane. I'll take you to those briefly. And we also say...
But there is no case that's addressing this issue at all, is there?
Not precisely on the point, but we say where the boundary has fallen to be analysed before, on at least 3 occasions, by the Court of Appeal, those approaches are identical to the one which we advanced before you this morning. We say there's no need to look at Hansard, and we adopt the reasoning of Lord Justice Laws because there isn't ambiguity of the necessary kind. And even if there were ambiguity, what we get from Hansard is simply not clear enough to help. And perhaps critically in this case, if one looks at Clause 48, which became Section 49, it's so different from what was being considered in advance that one can see essentially that whatever was said in advance isn't going to help us with the task we have today. Turning then to the question of application and what it means that when we're considering who is responsible for meeting the cost of the nursing care provided by a registered nurse in a home that provides funded nursing care to those residents, what impact does Regulation 18 have, or the need for a nurse to be working there? We say it doesn't compel the answer that Mr. Gordon has submitted it does. First of all, we say logically one has to ask if social care, which is the responsibility of a local authority under Section 21, just happens to be done by a nurse, then, as we understand it, it's common ground that doesn't somehow transform it into nursing care. Why then would the existence of Regulation 18 or the need for the nurse to be there at the time that she is fulfilling this statutory obligation on the local authority change things? And we say the important way to approach this issue of application is to bear in mind that Section 49 is essentially a circumscribing of Section 21. And Section 21 imposes an obligation on the local authority. So if one were to look at it in the terms of a Venn diagram, there's a sphere which is social care, like this, under Section 21. What Section 49 does is carve out a chunk from that and say, this area is an area which you may not fund. The first part of Section 49 is to say, well, look at what nursing care by a registered nurse, but then it narrows it and says it is then only what needs to be done by the nurse. So you start off with a big circle of Section 21, you get a chunk bitten out of it, but then that's narrowed by those critical words which come after other than. And if one understands it in this way, we say that you can easily see that a local authority remains not prohibited from paying for the social care which it was always obliged to fund. But if you look at it through the other end of the telescope via Section 3, which I'll come to in a moment, which is the obligation on the NHS, or in my case, the local health boards, they only have an obligation to provide what is necessary to meet reasonable requirements. And in deciding what is necessary to meet reasonable requirements, the case law tells us that, first of all, they are entitled to take into account what local authorities are obliged to do. And we say that they are entitled to take into account how, in fact, care homes arrange their businesses, more particularly bearing in mind that there is this calculation of a flat rate arrangement, which is how the duty is effectively discharged.
So you say there is this. flat rate arrangement? Where do we get it from?
Well,
Or are we just meant to assume that that's how it's always been done, and therefore?
Well, we explain in our case, my lord, how it's done, and it was accepted by the Court of Appeal that was how it was done, and that no issue was taken.
I understand how it's done. What I don't understand is where you get it from in the statute, because the statute is concerned with.
Well, the statute doesn't compel it. It's the case, as I indicated a few moments ago, that was the approach that was taken when Section 49 came into force.
Does the statute authorise it? Because, I mean, the statute is concerned with prohibiting local authorities from doing certain things, from providing certain things or arranging certain things. It's not talking about what it can pay for, it's talking about what it can arrange.
Well, no, the way perhaps one can see it working is this, that Section 21 requires the local authority to provide social care. We know that in the vast majority of cases, the way in which it's provided is by purchasing it from a private care home. And so if you are a resident who's at the end of the spectrum, who is 100% social care, then essentially the local authority will set a rate locally, and in fact there's been lots of litigation about how that's done as well. But the local authority will set a rate and say we'll pay X pounds per week for people who fall within this category. Now, in relation to people who fall within the second category, namely people who are entitled to funding nursing care, when they are placed within a home, then the local authority again will pay that rate that it has decided, and the NHS will then play this other flat rate in respect of this other aspect or element of their care needs.
Now, these two categories of people, those who are entitled to continuing healthcare and those who are entitled to funded nursing care.
Oh, no, lady, I'm talking about the other two, the 100% social
I know you
care.
are, but I want to know, you're making a great deal of these categories of people. Are they prescribed by regulations in Wales, or are they just administrative categories?
No, the regulations, the way in which someone falls within the categories is prescribed by the directions. And again, this is set out in our case,
Yes.
my lady.
Which paragraph?
That's why I'm asking you.
If you have a look at page 126, that takes you to the directions, and the directions themselves are in the authorities bundle at
Yes.
18. So essentially,
What's the authority for the directions?
they are made under the 1948 National Assistance Act and the 1977 National Health Service Act.
Not in Wales.
1977 Act.
They were, I think, if you have a look at memory stick page 889, you can see the directions.
And they purport to be made under section 16BB4 of the 1977 NHS Act.
Yes, I think.
Where are we looking now?
It's within the authorities bundle, volume 1, behind tab 18, memory stick page 889. So these are the directions. And then if you turn to page 891, and paragraph 2.1, the relevant authority shall provide a qualifying person for whom it has responsibility on that date with such nursing care as appears to it to be appropriate, having regard to the nursing care provided to that person in the relevant premises in which the person. So that captures those people who, before Section 49 came into force, were treated as 100% social care people. And in the aftermath of Cochrane and the identification of a category of persons who were not 100% social care but were entitled to an element of nursing care, these directions provided for their identification and funding. And those people were originally that element of care was originally called registered nursing care. And my lady will probably remember it had 3 bands, but that proved too difficult, and so it became funded nursing care in 1 band, which perhaps also indicates why it ended up as being a flat rate which was applied across a class of individuals, albeit that within that class there'll be people with, you know, greater and lesser amounts of need.
Sorry, so it's just 2-1 we need, is it? That is what imposes the obligation on your authority
Yes.
to provide.
Well, that's for earlier people.
It's 3-1 is the
3-1
obligation.
is the
3-1 is that, sorry, yes, and then it's
3-1 is the
for the
important.
new people. But it's in the same terms. And it's where then that provides that there's an eligibility assessment.
It isn't exactly in the same terms. But basically it's saying you assess this person's need for nursing care and then you provide it.
Lady, it's pointed out to me it's 1 o'clock, or indeed after 1 o'clock.
Yeah.
Well, my machine says it's 1 o'clock. Is that a convenient moment for you, Miss Morris? Well, we'll adjourn now and look forward to hearing from you again at 2 o'clock.